Good evening. This week, a new European Court of Human Rights comes into being, replacing the old part-time, expensive and arthritic institution and claiming jurisdiction over 800 million people from Greenland to Vladivostok. It's said to be the only court in the world where an individual can make a complaint against his state for a violation of human rights. Britain's record at the old commission and court wasn't particularly glorious. How often this country will be taken to the new court in future is rather questionable, because as we speak, the European Convention on Human Rights is being incorporated into British law on the statute book now in force in January 2000. It'll turn the presumption of our common law on its head. Instead of being allowed to do anything that's not specifically prohibited, we will now have laws based on rights. They're unexceptionable at first sight: a right to life, freedom of expression, right to marry and have a family, and so on. But they are broadly drawn and will potentially affect not just every operation of the law, but every public institution, or indeed private one, that performs public functions. Those who support this move say it'll be a step change towards a fairer, more decent society, with gaps in our piecemeal legal systems plugged. Those who oppose it say it'll mean an avalanche of litigation, and it'll politicise the judges, who'll have wide powers to resolve conflicts between the old and the new. There are deeper moral issues here, though. Will this result in some people's values being inflicted unnecessarily on others, bringing about a less rather than more liberal society? And anyway, are we now far too preoccupied with rights when we ought to be talking about responsibilities? That's our moral maze tonight. Our regular panel: Janet Daley of The Telegraph, the constitutional historian Dr. David Starkey, Dr. David Cook, the medical ethicist from Oxford, and Professor Ian Hargreaves, the journalist and commentator. Ian.
Well, I think it's a good thing to decide what we aspire to and to try to set it down. The British have never been very good at it. I rather envy the French, their Declaration of Rights of Man, and the American Revolution's similar statement. We tend to have to turn to Blake's Jerusalem when we want to get all lofty about our aspirations. The European Convention lacks the nobility of language of some of those other great declarations, but it's too easy to forget how some of the most basic rights it represents have been threatened in our own time. Freedom of expression and fair trial in Northern Ireland, racial equality in the Stephen Lawrence affair, and in many other examples one could give. We need it.
Janet Daley.
The modern idea of legal rights is an 18th century concept which grew out of the notion of a social contract. The government would guarantee to protect a certain specific list of the citizen's rights in return for the citizen accepting the rule of law. And as Ian says, it's the model for the American and the French modern republics. But Britain has a much older democratic tradition than that, in which the state does not lay down what you do or do not have a right to do. As you said, Michael, you're free to do anything at all that isn't specifically outlawed. And most important, to outlaw something requires an act of legislation by a democratically elected parliament. We're about to trade in that principle of inherent freedom for a list of legal rights which will be prescribed and adjudicated by an unelected, supragovernmental body with no democratic accountability. It's a bad bargain.
David Cook?
Well, I find all this talk of rights very confusing. A confusion about rights and freedoms, confusion about rights, wants and needs. I'm not sure of the difference between legal, human and natural rights. I understand legal rights with the correlative responsibilities, but the notion of human rights. So I hope this evening that people are going to help me understand the definition, the nature, the basis, the scope, and the interpretation of rights. They're going to tell me how to judge between competing rights and what limits there are and what sanctions for breaking them.
Easy. David Starkey?
Gosh. I think there are three things worry me about all this. The first is the statement that this convention, you began, Michael, by describing that it was going to deal with 800 million people. And the preamble to it boldly says they have a common heritage of political traditions. It will be difficult to find a statement about European history that was more untrue. That's point one. Point two, very differently from actually what Ian was saying at the beginning of the programme, this arises from an English tradition. Liberty is almost an English invention. We didn't need a revolution to have it, unlike the French. And I would remind you that the fate of the French Declaration of Human Rights was to be shut up in a large chest for the duration of the French Revolution, the moment it was enacted to make cutting heads off rather more easy. And the third point, and this is where we come down to the absolute specifics, if after all this lofty language, I can recommend to everybody here and everybody listening at home actually to read the European Convention. You will find that unlike the American Declaration, these rights are extraordinarily tightly constrained by notions like public health and morals, through which imaginative judges could drive any coach and horses they chose.
David, thank you for that analysis. And move on to our first witness, Angela Mason, who's Executive Director of Stonewall. I mean, I know you've got general points, and we'll get into them in a minute, but you've got a specific interest in all this. You've lived in a stable lesbian relationship for, what, is it 25 years?
Yes, that's right.
And
Since
you've had
time
a child.
immemorial.
Immoral.
And you've had a child yourself by artificial insemination. Now,
That's
under
right.
this European Convention on Human Rights, it guarantees, with a lot of qualifications, as David Starkey has mentioned, the right to actually to marry and have a family. But there is the thought that it opens up the possibility of your partner being made a de jure parent. Why would that be important to you?
Well, I think it's important to us all as a family, and it's particularly important to my child. I mean, if we did a case, I think it would probably be my daughter saying, well, here I am, I'm glad to be alive, I've got two parents, hopefully she'd say two good parents, and I want my family to be treated in the same way as everybody else's family. And that means I want the legal status of both my parents recognised.
And the general question, why do you think this, and if you like, the wider concept of enshrining human rights in law is good for society as a whole?
Well, the reason that we have the European Convention of Human Rights is because after the Second World War, this country and other European states wanted to get together and set out really what would be the basic building blocks of a democratic society. And one of the most important points of the convention was that it should protect the rights of minorities that had been so terribly abused under fascism. And I think it is important, speaking from my own point of view, to have the rights of the minority respected, and sometimes respected and upheld against the views of the majority.
David Cook.
I want to come in a moment to this notion of parents and family, but first I want to ask whether or not you think there is a right for fertility treatment for every woman.
I think that we all should be able to have the choice to be parents. Now, obviously, that choice has to be exercised in a real world where there are scarce medical resources, but that is a different question.
I'm interested in this notion of parents. You said that your daughter talks about two parents.
Yes.
If your daughter goes to court and says, I want the right to have a father, does she have that right?
I don't mind if she goes to court and argues for anything, but in fact what she has are two parents.
And isn't one of them male and one of them female?
No, they're two same-sex parents, and what she and we would be saying is that we are parents just like any other parents, and she has the right to have her parents recognised in law.
But she does have a biological father.
She does have a biological father.
It's interesting that the notion of founding a family in the European Convention depends on the right to marry. And the right to marry is said men and women of marriageable age have the right to marry and to found a family. So it looks as if the European Convention is quite clear. It's male and female who are at the heart of founding families.
No, we're talking about two slightly different things. I'm not talking about the right to marry. There may be lesbians and gay men.
To found a family, because that's what it rests on.
The lesbians and gay men may go under the European Convention and argue that they have the right to marry. I'm not sure that would succeed. That seems to me a different question from whether a child alive now in this society with two parents should have those parents recognised in law.
But isn't there a proper recognition in law that the father is the male parent? You wouldn't have managed to have a child on your own, the two ladies together.
The legal situation with regard to my own case and donor insemination is that my child doesn't have any legal father whatsoever.
But biologically there was a father.
Biologically there is a father, but she has no legal father.
Janet Daley.
David Cook asked you whether if your daughter decided that she had a legal right or a moral right to know who her father was, say, let's put it that way. Suppose your child, just hypothetically, rebelled in adolescence and decided that what she really wanted was two parents of opposite sexes. She wanted to know who her father was, but her father felt that he had an absolute right to anonymity. Now, how could those two rights be reconciled? How could a court decide whose right took precedence?
Well, first of all, I would have no objection to my daughter knowing who her father was.
No, I'm not
I don't
talking
have
about
that objection.
your objection. I'm
But
talking about the father's objection.
One of the useful things, I think, about the Convention and the new Human Rights Act is it gives us a way of adjudicating differences of
does
view.
it, you
I think it does, because there's a new test introduced by the European Convention, and that is the test of proportionality. And the question is that if there is an interference with an individual's right, can that be justified by some greater common good? And that's a new test in
Quite.
English law,
But-
and it's one, say, for instance...
But let's take a specific example. How
certainly.
do we decide whose good transcends another? Suppose the child says, it's absolutely psychologically imperative for me to know who my father was, but the original understanding with the father is that he would remain anonymous for life. Now, how can any court possibly make a moral adjudication between those two?
Well, the way in which courts approach these questions, and I think it is the right way, is by looking first and foremost at the interest of the child, the welfare of the child. And any question before a court that concerns children, I think that has to be the starting point.
Right. Now, can I say to you that if that was the case, and that might be absolutely morally desirable, it would have nothing whatever to do with the question of rights. The question of rights doesn't come into that at all. What comes into that is the question of compassion, the fact that we put children's concerns above the needs of adults. It doesn't have anything to do with rights.
But it does come into it, because at the moment, if my daughter were to argue, I don't know if she will, but if she were to argue that she thought it in her interest to have both her parents recognised, there's no way in which she could bring that question into our courts at the moment. The Convention Human Rights Act does give her the opportunity to raise those questions. I don't know what the court would decide, but it allows those
an opportunity then for a great many conflicts, moral conflicts, which judges would have to decide.
Well, at the moment, the difficulty is that these questions really... It's just a practical difficulty. They don't come before Parliament because Parliament is dealing with other matters. It hasn't got time to deal with all these type of questions.
David Starkey?
Angela, you're presenting the incorporation of the Convention as opening up new opportunities. One of the things that strikes me on reading it is actually the tightness of limitation. I mean, let's look at something that gay people are very interested in, that somebody perhaps like myself, or certainly Peter Tatchell, might be concerned with, which is freedom of expression, which is limited here explicitly by national security, territorial integrity or public safety, the rights of others, morals, and whatever else it is here, health or morals. Now, how on earth, with a broad statement like health or morals, would you justify expanded rights for gay people?
Well,
in terms of expression?
In fact, if we look at the decisions that have already been made by the European Court of Human Rights in Strasbourg, they have decided that, for instance, the complete criminalisation of homosexuality in Northern Ireland, in Ireland...
Sorry, forgive me, that's
Cyprus,
not to do with freedom of expression. That's not to do with freedom of expression.
That's to do with the right to privacy. One of the...
Can I just... Forgive me, Angela. Can we focus on the question of freedom of expression?
Certainly.
Because the great contrast between this declaration and the First Amendment. The First Amendment is absolute. It's clear. It's freedom from. This is highly conditional. And can I also put to you that when the issue, for example, of blasphemy laws, which Court Tatchell came up in Austria, blasphemy laws were upheld.
Well, I don't...
Because of morals.
This is
public
absolutely not a gay rights charter. I completely agree with you. But I think issues like Section 28 of the Local Government Act, which is about what local authorities can do to promote homosexuality, prohibits them from doing that. I think there probably would be a freedom of expression case on that legislation.
Ian Hargreaves. Ian, thank you, David. Ian
Isn't
Hargreaves.
it the case to follow up David Starkey's point, Angela, that the actual record of the European Court on freedom of expression issues is far more liberal than it has taken liberal pro-freedom of expression decisions almost on every occasion it has been asked to do when issues have come through the national court system in Britain, for example.
I think that is the case. Yes.
Could we have examples?
Yes, we could have the example of the disclosure of journalists' sources, which has been actioned at the European level.
Very self-interested remark here.
Well, if you want to talk about freedom of expression, David, let's talk about it.
Real ordinary people, not just self-interested journalists.
We can come to that later on in the programme. Thanks very much indeed. Angela Mason, thanks very much indeed. Our next witness is Brian Micklethwaite, who's editorial director of the Libertarian Alliance. Mr. Micklethwaite, does turning the concept of human rights into law make us more or less free as individuals?
It all depends what it says, doesn't it? Can I start with a preemptive apology, which is that I came to this almost completely naively, like a newborn babe reading this thing for the first time. I'm prepared to bet that I'm the most ignorant person of everybody involved in this programme about what these things actually said.
No, I wouldn't bet on
so
it.
I, almost like a literary critic, I came to this document for the first time. And of course, it all depends what it says. My impression is that it's a very conservative, very limited sort of document. Andrew Pudifat told me beforehand that it was written by a conservative lawyer 50 years ago. That makes very good sense to me. This is not, for example, a gay rights charter. It's not a machine for teasing out the nuances of the rights of journalists to conceal their sources, that kind of thing. It's much more a kind of core curriculum, a kind of national curriculum for what we mean by a straight-up decent European state, as opposed to grease under the kernels. That's what it seems to me to be about.
Okay, but on this general point of enshrining rights in
rights.
in law, there are rights and rights.
I was looking at rights. I was looking in this document for positive rights, which I think are a bad thing, despite the word positive.
Define positive.
Positive rights would be something like not just the right to have in vitro fertilization, to take Angela's example, but my obligation and our obligation here to pay for it, for example.
What about the positive?
To make it available.
Responsibility.
Hang on, Ian.
Well,
Ian
the point I'm looking out for the kinds of rights which impose obligations on the rest of us, other than simply the right to refrain from something. I mean, I think all rights impose responsibilities on the rest of us, but it's when you start sort of saying that people have a right to a university education, they a right to flood relief and so on, that's when I start to get nervous.
Got your point. Ian Hargreaves.
Positive rights, bad. Negative rights, acceptable. Is your argument?
Negative rights necessary.
Yes. What about the right to be treated equally by the police, irrespective of your skin colour? Is that a positive or a negative right?
I don't know. What would you say, David? I don't know. What do you think?
Michael will
I would have thought I'd have thought it's a right where this concept doesn't clarify.
I would have thought it's an example which causes your two categorisations to fall into disrepute in 30 seconds.
Yes. No, just because there are grey areas in the principle, it doesn't mean the principle's worthless.
But it's not a grey area. I mean, what about the example, you mentioned an example...
I mean, can I be clear? I'm against the police being racist and I'm in favour of them. The principle we're alluding to is one I agree with.
I don't doubt that you are, but if you want to say that the right, for example, to... What would you say about the right to education?
I would go with the language of the U.S. Declaration of Independence, wasn't it? The right to pursue education would seem to me the important thing, but not the obligation of the rest of us to supply it.
So is that a positive right or a negative right?
I'd call that a negative right. You know, if you want to educate yourself, I'm not allowed to interfere with that process.
No, surely it's a positive right. I mean, the right to have a basic education is something...
I refuse to go on answering these questions because Ian, come on, Ian,
let's
shut up and
examine the definition
Ian,
that you gave.
Ian.
Something that imposes a cost on others. The right to basic education certainly imposes a cost on others.
Yeah, I'm against that, if that's what you mean by the right to basic education.
Right,
yes,
so you're opposed to a right to basic education.
Which doesn't appear in this document. So
That's
why
right,
on earth?
that's right.
Why
That's
on earth
right.
are we piddling on
All
about
I was
it?
doing exactly, Ian. Thank you, David. All I was saying was that my reaction to this document is that it didn't have a lot of those sorts of contentious rights. The rights that it had were the kind of rights that that almost everybody who takes rights seriously agree with. And I want to echo completely what David said, that the striking thing to me about the document wasn't that it contained bad rights, but that it defended good rights so very equivocally, which in different historical circumstances could, in your words, be driven over by other sorts of judges.
Let me try and understand where
That's the libertarian objection to this.
Let me try and understand where you're now coming from. You've now discovered, having read the document, that it describes a basic minimum of rights which everybody could agree with. So what's wrong with it?
Sorry, did I say there was something terribly wrong with it?
Well, I thought that was your opening premise. Perhaps I misunderstood you.
No, not at all. In fact, I'd like to disagree with what Janet said about this English common law thing.
But hang on a second.
I think the English common laws are gone.
If you give her a chance to ask you a question, you can do that. Janet Daley.
You mentioned that bills of rights are inherent. That this Bill of Rights was terribly conservative and therefore unequivocal about the things you wanted it to approve of. Can I put it to you that bills of rights are always conservative? The American one particularly so. It guarantees things like the right to bear arms. It becomes an instant antique. As soon as you set down in writing the set of legal rights that you want to guarantee to citizens, you're embalming what happens to be the intellectual fashion of the day. And in America, it's extremely difficult to amend the Constitution. That's one of the difficulties America has, for example, with the right to bear arms. Isn't that a problem with setting down a Bill of Rights?
It's a problem if you want to get rid of the right to bear arms, yes.
So it's a problem in that it's inherently
It's a problem if you want to introduce income tax into the United States. The Constitution says you mustn't.
Yes, that's right.
But and that brings us on to another point, which is that if you have a pretty much united ruling class who've made up their minds they want to change things, then even a really strong constitution, which this one isn't, or a strong declaration of rights, which this one isn't, even that won't necessarily stop
Sure.
it.
Isn't it inevitable, in fact, that whoever the judiciary are, whether it's the American Supreme Court or whether it's this international court in Strasbourg, will in fact go with the times. They will go with the enlightened, fashionable view of the time. And as the times change, every generation will in fact reinterpret this.
Indeed. And
so it's meaningless.
That's my excuse. Ian was sneering at me for not having read it. That's my explanation of why I haven't read it, because I think practice and ideas of the kind discussed by teenagers at universities are just as important to the contents of documents like this.
But that's the common law tradition. That's the common law tradition. In a sense, it's legitimate for law to be created by precedent, because it's a legitimate function of the law to go along with the prevailing view of the time.
Well, my point is not that the common law tradition can't be sort of reinvigorated in the manner you've just described. It's just that in terms of English law, British law, it's pretty well dead on its feet, I think.
David Cook?
I'm interested because basically what you sound as if you're saying is you're much more interested in freedoms than rights. But if that's the case, I'm wondering what kind of responsibilities we have and whether or not they are transnational, whether or not Europe has some kind of responsibility to give us this kind of freedom or to give us this kind of right, if we buy that language.
What makes this into a morally mazy discussion is that I mean, I appreciate that this is not the same as the European Union. We're not talking about the same institutions, but I'm sure that somebody who was for the European Union would be for this. You know, in principle, it's European Union. It's the gathering together. It's the undermining of sovereignty.
Bigger than the European Union.
I know. Greenland was mentioned. I appreciate
Eastern
that,
Europe
but
as well.
I can imagine somebody. This wouldn't include me, but I can imagine somebody disliking this document because it's good, if you see what I mean.
But does it have some kind of responsibility for transnational ways of inflicting morality on people?
I hesitate to tell people at the other end of Europe how they should run their governments. I mean, my hesitation about telling people what drugs they should take or what sexual practices they should indulge in their bedrooms actually applies to politics in faraway countries. I'm nervous about just saying, yes, we should tell the Turks what public morals are.
We don't need to instruct the Turks, even from the studio of the moral maze. But if you were a citizen of the Czech Republic or Romania, would you be pleased if your government decided to sign up to this convention?
Yeah, I'm pretty sure I would. Yeah. I think that's.
Isn't that its value? Doesn't that make it absolutely obvious what its value is?
Should we be pleased that there are, say, Serbian or Croatian judges who have a rather different conception, perhaps, of democracy than we do, adjudicating over our parliament?
Say that again?
Should we be pleased, conversely to what Ian just said, should we be pleased that we might have, say, Serbian judges? We don't approve terribly of Serbia's conception of democracy.
My guess is that Serbian methods of doing things at present are outnumbered by
Well, that's
European
that's not the
decencies.
point.
But I mean, in a future Europe, 60, 100 years where Hitlerism is back in with a different name, and governments are just making it up as they go along. Well, yes, yeah. I mean that's the danger that national doubts or something of decency might be swallowed up.
Do you think I would return to the...
I mean, that's the case against European Union, isn't it?
Yes.
to return... Oh,
Couldn't have said it better myself.
Which I share, actually. I'm in...
Can I just drag you back to the question posed at the beginning? Do you think this is a way, or there is a danger, that it is a way of some people's values being inflicted unnecessarily on others? Unnecessarily, I suppose, being the key word in there.
I think it's a danger, but I think that whether or not you're arguing about a document or just day-to-day political practice, things like rows about female circumcision, is it our business to be telling African societies, African gentlemen, African ladies?
Included in Europe.
I'm sure these these rows will go on anyway, whether or not they're connected with a debate about a document.
Brian Michael, thanks very much indeed. Now, our last witness is Andrew Puddafat, who's director of Charter 88 and a member, incidentally, of the new government task force set up to assist in the implementation of this human rights bill that's going onto the statute book this week, I think, isn't it?
Yes, Monday, I think, at Royal Assent.
Right. Aren't we in danger of replacing the, if you like, the tyranny of the majority by the tyranny of minorities?
I don't think so. I think the European Convention is a fairly, and I think you have already discussed this evening, a reasonably conservative document. It's 50 years old. It was one of the earliest human rights documents drafted by two British lawyers based on British common law values and freedoms. And it was designed to provide a framework to underpin the emerging democracies of Europe. And so by incorporating it in our law, we're simply bringing ourselves up to, I think, a certain set of minimum standards. Up to date, yes, and I think it's...
No, not up to date.
Not up to
doesn't, not up to date. It's 50 years ago, but there are obviously other human rights standards since then. But I think it's a good, positive document, and I think something we haven't touched on tonight is that what the government has done is not provided the courts with the absolute authority to make the kinds of decisions that we've been discussing. It's very clearly said that government has a responsibility to produce what it calls human rights impact statements, accompanying all legislation. Parliament has the ultimate right to determine the laws of the land in accordance with the Convention, and the courts are there to police it. There's three very different kind of arms there.
Janet Daley?
You uttered a very interesting sentence just a moment ago. You said there are more up-to-date standards of human rights since then. Isn't that the essence of the problem? That the standards of human rights, what we consider an appropriate human right, varies from generation to generation. We updated. The reason that there's nothing in the American Declaration of the American Bill of Rights about, for example, not having a right not to be a slave is because most of the people who drafted it were slave owners. It would have been unintelligible to them to have such a right. But now we consider that very strongly to be part of a right. Why do we need a document that's going to become an immediate antique that will be painful and difficult to revise when, in fact, with the natural flow of things, we update our conception of human rights all the time in a democracy?
It won't be painful or difficult to revise with the government's model because, no, it can simply introduce supplementary legislation at any time. It's not judicially entrenched, so it's perfectly possible for the government to add in additional human rights standards. And the fact that standards, if I could just answer your question, the fact that standards evolve over a generation doesn't invalidate the existence of standards in the first place. Of course, as Thomas Paine said, every generation should have the right to make its own arrangements. I think the model, the way the government's introduced this, and this is a very important distinction from the American model, allows Parliament and future parliaments the flexibility to update those human rights standards.
We're talking at cross purposes. You're talking about the convention, but I'm also talking about the court at Strasbourg, which in a sense is supra-governmental. It transcends the power of individual governments. Do you agree?
It's a final court of appeal on the convention.
Yes, yes. So in effect it has the function of the American Supreme Court, but without the checks and balances of the government, without being any susceptible to political or democratic accountability.
It's very clear that it has what it calls a margin of appreciation, which is those areas which it regards as the property of the democratic parliaments or assemblies of the countries that make up the European Convention diaspora. And it says, in these areas, we do not choose to intervene. There's been very clear examples where, so for example, on a question like abortion, although there have been systematic attempts to invalidate abortion laws in European countries by various right-to-life groups, the European Court has always said, look, this is not our business, this is a political issue, it's a democratic issue.
But it does consider freedom of expression to be part of its remit, doesn't it?
It has, and it's laid down, and I think...
And that's pretty basic. I would say, if anything, it's more basic, perhaps, than the right to abortion.
Possibly, but it's certainly been, in the case of Britain, I think very beneficial in freedom of expression.
But whether you think it's beneficial, if you'll forgive me, is neither here nor there.
No.
And whether I think it's beneficial is neither here nor there. The point is that we have given a power to a non-governmental agency, an agency that is not elected by anybody, that is not accessible or accountable to anybody. No, but the courts within our own country are determined by our own political culture and our own democratic traditions. This is a court. Sorry, Michael is telling me.
Your question is...
Yes, go ahead.
Well,
My question is, isn't it dangerous to give that kind of power to an agency that is susceptible to no democratic accountability at all?
No, first of all, it's a treaty we've signed, and if we don't like it, we can abrogate the treaty and withdraw from it. So our government remains... No, of course not, because I think the rights in the Convention are fundamental human rights that are necessary to underpin all democracies: the right to life, the right to due process, the right to freedom of expression, the right to privacy, the right to freedom of information. I think these are the legacy of the 20th century. They're not 18th century natural rights. They are what we've learned is necessary to provide fundamental freedoms.
David, thank you, Janet. David Starkey.
I have to say that I am... unlike Brian Micklethwaite, I had actually read this thing before, so I wasn't surprised by its extraordinary restrictiveness, particularly in contrast with the American Bill of Rights, with the absoluteness.
Yeah.
Now, how happy are you that lawful detention of persons is subject to the following conditions: that it's perfectly all right to detain people for the spreading of infectious diseases, which would presumably mean that AIDS patients could be detained, for persons of unsound mind, which we can put anybody inside, including everybody around this table, alcoholics, which also covers most people around this table, drug addicts or vagrants. How happy are you for a right to imprison vagrants?
Well, I'm certainly not happy with all of the exemptions in the European Convention. I understand that when drafted 50 years ago as a treaty between a number of signatory states, they had to produce, if you like, a weaker model than we would have aspired to in this country. But I'm confident that the courts will not simply...
So they'll ignore it. So the things that are old-fashioned and that just happen to be there because it was written 50 years ago.
As Angela said earlier, there's a doctrine of proportionality, and the courts are obliged to consider when a government uses one of those exemption clauses to infringe a right, are they acting, if you like, proportionate to the menace that they are alleging? So if, for example, the government says, right, we suspect there is an Irishman in the country who's going to plant a bomb, we're going to intern all Irishmen in the public interest using this exemption clause, the courts are quite likely to say, hang on, that's wholly disproportionate to the nature of the threat. Just as the European Court has used that test of proportionality over the last 50 years, and there's a fairly established body of jurisprudence on this, which I'm sure you're familiar with. So I think we won't... I don't like the exemptions, but I don't think they're necessarily going to have as damaging effect as your, I think, slightly mischievously caricatured question might have implied.
It wasn't a caricature, because let's actually look at an area where it's happened. For example, the fact that the European Court has upheld the highly restrictive blasphemy laws in Austria. And we know that blasphemy is actually providing one of the most interesting test cases of freedom of speech here. And yet the limitations of public health and morals are held to uphold, to allow these extraordinary restrictive laws, which in America would be instantly struck down. Why are you supporting the introduction into Britain of something as regressive, as old-fashioned as this?
Well, I'm supporting it as a step towards the creation of a rights culture in this country, as a step towards creating a set of minimum standards that I think we can develop from, we can build upon, but it's there is public acceptance of the document, and I think it's a place to start. In that particular case, I think the European Court, it shows that the European Court is very reluctant to interfere with issues that it regards as within the jurisdiction of the democratic cultures of each separate country.
But can you just clarify, as a member, a government advisor here, whether or not churches and religious bodies will or will not count as public authority, which are going to affect public? Will they be required, for example, to marry people that they wouldn't normally marry?
Well, that's
Same-sex relations, for
that
example.
I think need to be tested in the courts. They are public. If they're carrying out a public function, they will have to abide by the provisions of the Act.
So
now,
the law will force
the
churches
government
then to go against their basic fundamental beliefs.
Well, not necessarily. It depends on the decisions the courts arrive at, and we don't yet know what they are. And it depends on the case. If the church comes forward and says, look, it is not a human right to force us to marry two same-sex people in church, they can marry in a civil ceremony and uphold their legal rights, the courts may well say, well, that's a perfectly reasonable outcome. I can't prejudge cases in the future.
So the Italian court is going to have a Muslim as pope, then?
Certainly not. That's a silly thing, actually. I mean,
No,
clearly the
it's a concern
Catholic
because
Church will elect a Catholic.
I
That's
think
not
he
a-
suspects you of being mischievous as well as
bit
David Starkey. For heaven
What
forfend. Ian
how
Hargreaves.
nice to have companions in
Ian,
sin.
thank you, David. Ian Hargreaves.
wonder, Andrew, whether we might come very briefly back to a point that David Starkey made right at the beginning of this, and Janet, in a sense, picked it up, which is that they argue against this on the grounds that, in David's words, Europe doesn't have a common political heritage to build from, and in Janet's argument, there isn't a political culture there which can legitimise the activities of a court in Europe. What do you say to that?
I think that human rights have universalist aspirations. They represent a set of fundamental standards that Europe learned out of the Holocaust. I mean, one needs to remember that this is the origin of the European Convention is not the 18th century doctrine of natural rights. It's not the unrestricted First or Second or Third Amendments. It is the experience, and that may be the case, but it is the experience of the Holocaust and the Gulag which told people in Europe we had to have certain fundamental rights guaranteed if we were to have a civilized democratic culture in this continent.
Andrew Putterford.
Thank you.
Thanks very much indeed. A rights, Andrew was just saying, it's building a rights culture in this country. Do you welcome that or shudder at it, Janet?
Well,
I kind of know the answer there.
A rights culture in the modern American sense of a whinge culture would be, and a sort of lawyer's paradise would be absolutely appalling compared to the sort of residual freedoms that Britain has traditionally had. But it's interesting.
Isn't it going to be a lawyer's paradise?
Yes.
Most of this programme has been about how lawyers are going to have to arbitrate between competing rights.
Absolutely. Lawyers and judges. I mean, coming from a country that has a written Bill of Rights, I can tell you that it is inherently conservative. It is inherently a force for reaction. When the Equal Opportunities Amendment was attempted, in the great heyday of feminism, when there was an Equal Rights Amendment, it never passed in America. There was such a laborious procedure for passing an amendment to the Constitution that it never actually passed. In this country, the Parliament was able to respond within the length of one Parliament to pass an equal opportunities, a piece of equal opportunities legislation, which was identical to the ERA amendment in America.
We're not talking here, Janet, about the creation of a constitution which can only be amended by that type of process.
You're talking about
we're talking about a bill
That's
which
right.
is about to become an act.
But I'm sorry, a Bill of Rights can't exist outside of what you're going to get is one bit of the package. You're not going to have any of the checks and balances of an American government. So you're going to have, in effect, a court that has all the powers of the Supreme Court without the power of the legislature and the executive too. It's going to be disembodied, free of any kind of governmental check and balance. That's even more dangerous.
David Cook, did you take Brian Micklethwaite's point about positive and negative rights?
Well, I think that what he was really talking about were freedoms. It's interesting, if he's interested as he was in negative rights, in other words, saying to people, don't do something, there didn't seem much wrong to me with the Ten Commandments, which told people not to do something. But I'm concerned about whether or not we're really talking about moral ideals, about aspirations, or whether we're talking about laws. And the flag has been waved that this is really setting up some kind of high level of ideals. But when it comes to it, it's about how lawyers are going to interpret. And I was really distressed to hear that churches are going to have to be dependent on how the law will be applied and interpreted, and individual and community belief systems going to be set aside.
Ian, were you still as enthusiastic for this idea at the end of this discussion as you were at the beginning?
Yes, and nor am I worried about the point that David Cook makes. I think that where churches like the Church of England take on the functions of the state in marrying people, they must expect that to be negotiated in a democracy. What that means, it won't mean what you were suggesting it's going to mean, because gay people don't have any civil right to be married in this country.
Sorry,
And the European Convention is
David
quite clear that marriage is about male and female.
But the churches aren't taking on the the function of the state. Quite the opposite. The churches were the first ones to perform marriage ceremonies. The state is taking on the responsibility of the churches.
Well,
we have to be very careful.
In English,
Obviously,
it's rather different.
the Church of England is in fact a state creation for its own purposes, and it seems to me if you actually have bishops sitting in a legislative assembly and actually intervening in the legislative process, it is perfectly proper that they be subject to this document. But coming back to it,
if
Michael,
I can draw you back from this ecclesiastical cul-de-sac here to your extremely good point about some of the fine print of the
I
Convention
am
on
very
Human Rights.
worried about this. It seems to me that for all Janet's rudeness about the American Bill of Rights, that has been a genuine libertarian document. It's been a document which has produced a quite remarkable culture of individual assertiveness and vigour against public institutions, which is what I mean by freedom from. This is a compromise. It's a compromise between a tradition of English common law on the one hand, an incredibly statist culture in Europe which says that people can only do things when the state allows them to do it. My great anxiety, and it's I think the one that Brian Micklethwaite was also indicating when he talked about the death of English common law, is that we're shifting, slithering towards the European position in which we can essentially only do what we're explicitly allowed to do. And just one second. At the moment, it may be all right. There may be a genuine democratic culture sweeping over Europe, but it won't always be like that. Europe has been dangerous. On the whole, Anglo-Saxon cultures have been free. Nothing whatever persuades me that that's gone away.
So, David, what is your answer to the question I put to Brian Micklethwaite? And let's embroider it, picking up a point that Janet made. If you were a citizen of Serbia, of the Czech Republic,
I would
of
welcome
Romania,
it passionately.
of Britain...
I would no. Let me finish. I would if I were.
Well, you need to let me finish the question before you can give an answer.
It would be useful
to the
if you
question.
put things into the same category before asking for an answer yes or no.
These are all
David,
countries
please
in
let him
Europe whose governments are signatories or potential signatories to this convention.
If
That's the
you
category.
actually think that the political and social history of Britain and Slovakia and the Balkans is similar, you should get off this program.
No, I don't. That is not what I'm saying. What I'm saying, David, is that if you are a citizen of those countries, do you think that this additional legal protection of basic rights is to your advantage or your disadvantage?
In Slovakia, may I answer your question? You've been asking it 4 times. In
Well, it'd be helpful if you
Czechoslovakia, where
answered
there's
it.
been a recent history of dictatorship, I think it will help. Here, I think it may actually hinder.
Won't make
Janet
a
Daley.
blind bit of difference if the political climate in those countries alters, if an economic crisis comes and the present governments are displaced by more authoritarian fascistic ones. Won't make a blind bit of difference. These will just become general pieties and platitudes that will have no effect whatever.
On the grounds of morals and public health.
What was the effect of the existence of these standards in the debate about civil liberties in Northern Ireland during the Troubles? 0?
Largely.
That's not true.
It didn't stop people being kneecapped.
No, but it also allowed people to pursue through the courts redress of their the violation of their rights, the alleged violation of their rights. It provided an important check and balance, in your words, in the system.
David Cook,
Whenever-
leave the last word with you.
Well, whenever we have to retreat to law in order to produce values, that's always a confession of failure. There are basic fundamental values which we have. Some of them are enshrined in these statements about rights, but that ought not to be the heart of our moral thinking and our moral behaviour. There are higher standards, and we don't want to get to the law.
That's it for this week. From our panel, Janet Daley, David Cook, David Starkey and Ian Hargreaves, and from me, until the same time next week when we'll be in front of a live audience in Winchester. Don't ask me why. It's a long story. Goodbye.
The Moral Maze was presented by Michael Buerk and produced by David Coomes.